The Federal High Court in Abuja has dismissed the suit filed by Kogi West Senator Dino Melaye, challenging the validity of the process of recalling him by his constituents. Justice Nnamdi Dingba, in his judgment, ruled that the Independent National Electoral Commission should go ahead with the recall process of Senator Dino Melaye, subject to the service of the petition, the full list, and the signatures of persons in support of the recall process. The judgment effectively terminates the earlier ex parte order made by another judge in the Federal High Court in Abuja, Justice John Soho, on July the 6th, directing parties to maintain status quo.
As soon as the plaintiff filed his action that the recall process, the 90 days paused, I mean, a stop is put to it, and that it starts from today. The balance, the rest of the 90 days, from when INEc started, commences from today. It was premature that they rushed to court, and what they wanted to do was to just come and then scatter everything, put impediment on everything. But I'm happy the court has clearly shown that it is not the responsibility of my clients and that of INEc to really serve the plaintiff with papers of this thing. If they want anything, then let them go ahead. If he's lucky enough to fault the verification at that level, or is lucky enough to ensure that the referendum does not succeed, then that is the end of the whole thing. But if he's unlucky, he goes.
Meanwhile, the Independent Electoral Commission, INEc, has moved swiftly on the court order. The commission says it will obey the decision of the court by availing the Kogi lawmakers copies of the petition. However, INEc's National Commissioner, Mr. Solomon Shoyebi, believes that the order of the court means 90 days window continues from the day the order was given. That's about 70 days to go in the process.
We'll look at it critically, but as far as we are concerned, we are aware that we have just 74 days to the lifespan of the recall. It was put on hold exactly 16 days when we started the process, before it was put on hold by the court. That was on July 6th. And the court now says, I'm freezing time for you. You start from where you stopped. That's the way we understand it. I want to assure you that we will not do something against the law, number one, but I want to believe personally that what the court said today is not that we should start the process afresh. We should start from where it stopped on July 6th, and then the frozen time was just 16 days. Make sure, number one, that we give him everything the court has asked us to give him, which includes the signatories and then the whole schedule of the petition. We'll accord him with that. And we have been told to in a period not less than 2 weeks, we will study all this and then we'll come with a timetable very soon. But I want to assure you that before the end of this week, something concrete will come out about this.
Responding, Senator Dino Melaye says he will appeal the decision of the Federal High Court because he believes the recall exercise is the mechanization of his political opponents who are bent on forcing him out of the Senate. Speaking on Channels Television Politics today, his lawyer, senior advocate of Nigeria, Mr. Mike Ozekome, interpreted the court's verdict directly, saying the 90 days window starts afresh after INEc provides Senator Melaye copies of the petition.
The court has said, in the spirit of fairness, in the interest of justice, Dino Melaye must be given a copy of the petition and all the attached annexures, accompanying annexures, including the signatories, so as to enable him prepare for the recall. And that until this is done, the recall process itself will not begin. That is why the judge also made an order that a fresh recall timetable with 90 days has to commence afresh. In other words, the earlier one is as dead as dodo. A new one has to recall. The executive has done its own by trying to recall Dino. The judiciary has done its own today, which decision will be appealed tomorrow. But the legislature is still watching, is still waiting.
Finally, on the program, lawyers have applauded the decision of the Federal High Court Abuja saying it's commendable.
I think the power lies with the people. The recall power has been entrenched in the electoral laws and the Constitution of the Federal Republic of Nigeria, and I think it's something that is worth giving a trial if lawyers in the final analysis do not scuttle the entire process through unnecessary litigation. If for any reason a legislator has been found wanting, the constituent has the inherent powers upon fulfilling the conditions laid down by law to call that legislator back, because he's a representative, he's there in a representative capacity. For as long as he ceases to have that capacity, the constituent has the right to call him back. And I think it's a commendable decision of the Federal High Court to ask for the whole process to be started all over again. If for any reason the former process was found to not have complied with what the law says, even though I have my issues with the law itself, because I mean, once a constituent has decided to call back a legislator, it should not lie with these so-called houses to determine the legitimacy or otherwise of that action. The headship of the houses only have the duty to affirm or rubber stamp whatever action the constituents have taken. And I mean, we should always respect the right of the electorate. The electorate is king in a democratic dispensation. And for as long as that remains the truth of the matter, I think we should commend the decision of the Federal High Court.
The judgment is applaudable. I'm in full support of that judgment. I find it laughable that the civil and political rights of the citizens of Nigeria is being truncated by opportunistic politicking. For me, the judgment is a triumph for Nigerian democracy, and I use this opportunity to appeal to Dino Melaye and his likes to refrain from further politicizing a very, very transparent and clear issue. The people of his constituents have a civil and a political right to determine whether or not to call for his return. If they have lost confidence in him, they should follow the laid down legal procedures for doing that. I understand that they have complied with the black and white letters of the law in formally seeking for his return by doing a petition to INEc. I expected Dino Melaye to wait for the outcome of the entire process, do his administrative checks. You know, in fact, there's a concept in law that talks about exhausting local remedies. So he should exhaust the statutory remedies that the law affords in dealing with INEc before thinking about going to court.
I believe the electoral law, especially as regard the recall of a House of Rep member or senator, I think that area should be amended. I believe they should be given fair hearing. Because anybody that doesn't like, if you don't like my face, you can just say, all right, you send me there, I'm not doing your bid. You can start in Nigeria, anything goes. Once there's more, you can gather 2 or 3 people, they start making noise, and before you know it, they will say that I'm no longer popular. They want to recall me. I think the provision of fair hearing, which Dino Melaye is complaining of, should be judicially pronounced upon, either by the Appeal Court or by the Supreme Court.
And that would do it for us on the program today. Thank you so much for watching. If you missed any part of the show, you can watch it again on youtube.com/Channels TV. And you can also follow me on Twitter at Victoria Ido. Thank you so much for watching. I'm Victoria Ido. Bye for now.